Hi, everybody. If you don't know me by now, you probably won't. Jonathan Cohen, still the president for a couple more months of this chapter, the New Jersey chapter of the Labor Employment Relations Association. It's actually a great honor of mine tonight as an attorney to be here with the retired Supreme Court Justice, Janie LaVecchia, who's one of our speakers. Many of you may remember that she was once the head of the Office of Administrative Law in New Jersey, and she took that experience onto the bench on the New Jersey Supreme Court and is presently retired now and working at McCarter and English and in the field of, among other things, being a neutral, like many of you in attendance tonight. So she brings that perspective along with her. We also have Kelly Adler, who I know from when she spent much of her career as a management attorney. Now she's on the other side representing employees frequently in employment and discrimination and other matters. So she's a partner with the law firm of McCumber and Luber, and she's going to be providing the employee side. Pursuant to our tripartite structure, we also have Ryan Carlson, who I first came to know when he was employed with the Metz Shiro law firm on the union side, and he's sort of done the opposite of Kelly, and now he's a partner with a very good law firm of Nuke Freeman and Sarah. They're really a powerhouse in the employer side, just like McCumber and Luber is on the plaintiff side. And Ryan's a good guy, and he's going to be providing the employer perspective relative to these issues about forced arbitration, arbitration generally of employment claims, but really in the background of a couple cases and legal developments, which Justice LaVecchia will kick us off with and give us some background. Before we jump into that, I do have a few housekeeping issues to take care of on behalf of New Jersey Lera, because if I wait to the end, I may lose some of you. So I'd like to do that now, if you don't mind. I do see that Bill Dwyer is here. Bill, raise your hand if you want to read the slate. Otherwise, okay. Emily, is it possible that you could get Bill into the spotlight for a minute? So what part of what we have to do according to our bylaws at our March meeting, which this is to announce our slate of candidates to be voted on at the May meeting. And Bill Dwyer, along with me and Jim Kinney, comprised I forgot what we're called, the nominations committee, perhaps, which I was able to do since I'm not up for office this year. So Professor Bill Dwyer of Rutgers University, you take the microphone, please, sir.
Sure. Hey, Jonathan. Thank you. So here's what we've got. So we've got a few changes on the board. John Sarno, Erica Tiener, and Pat Westerkamp have asked to step aside and create the opportunity for new people to come on board. As far as the executive board goes, Jonathan will be stepping aside as his term has expired. Lucille would be stepping into the role of president. Kurt would be assuming the role of vice president. Paul Montalbano would remain as the treasurer, and Jim Cooney would move from a board member at large into the secretary role. So that would create a total of 4 vacancies on the board, the board members at large, with all the executive board positions being filled. So the slate for the board at large would be Dean Burrell, Felice Busto, Bernie Corrigan, Pat Duncan, Ken Egger, Mike Freeman, Jim Kinney, David Leach, Lorraine Tesoro, and John Vreeland, and myself.
And Bill, I don't know if you were aware of this, but we had proposed at least 2 new members. I thought there was a third, but I can't remember who that would be at this point. But the 2 new members of the board would be John Crystal, who's with us today, the Newark Superior Officers Association, and Brady Montalbano from the law firm of Cohen Leader Montalbano.
Okay, so that's the slate.
Okay, so thanks, Bill. You can jump back into the peanut gallery if you don't mind. Thank you for that. So that's half of what I had to do. The other half is to let you all know that we are excited. It's becoming a regular tradition to have the National Labor Relations Board meeting with an actual member of the board being a speaker. And we're happy that for the first time in several years, we plan on being back in person at the Galloping Hill Golf Club in Kenilworth, New Jersey. And we will have with us Gwen Wilcox, who is a member of the National Labor Relations Board. She's now in, I believe, the majority, right, Dean, under the Biden administration. So we will have the opportunity to hear from her. This is an event where people like to come, give Gwen their business card and, get to know her and hear about what it's like to be on the National Labor Relations Board. So it's always an exciting event, and we're happy to be back in person and back at Galloping Hill. So I hope that you can make it there again. It's the first Monday of the month, May 2nd. I assume everybody here has pretty much navigated our website. If you've got people who might be interested, spread the word. NJ Lera is not a handshake secret club. The more the merrier, the more people that come to our meetings, the more we like it. And the more people who end up becoming members, the more we like it. All right, so I gave introductions. What I'm going to do now is hand it off to Justice Lavecchia to give a background about the legal developments that really precipitated this particular meeting.
Thank you, Jonathan. And let me say it's a pleasure to be joining all of you this afternoon. I look forward to the back and forth that we're going to have among the panelists today. Jonathan asked me to begin by giving a little background, as he said just a few seconds ago. So that's what I'm going to do just to kick things off. We're going to be talking about some cases and also about the Federal Arbitration Act, which, as most of you know, was passed in 1925. So you wonder, why are we talking about that now? What's new? Well, there's a lot that's new. But the FAA is important because it protects arbitration agreements that exist in interstate commerce. According to US Supreme Court law and the FAA, arbitration agreements must be treated on equal footing with other contracts within a state. That's what the case law from the United States Supreme Court has held. And they've also said that the FAA is enforceable in applying those principles in employment matters. So pre-dispute waivers of the right to go to court and instead pursue arbitration as the forum for dispute resolution, that's enforceable under federal law. And so too under state law by the court that I just recently left. The principle being federal law here is supreme. It's the supreme law of the land, so we have been following those principles. So what's new? Well, as case law developed and became more and more, to put it mildly, disfavoring, going against anything that disfavored arbitration, sentiment grew to, I believe, push back against that, certainly among members of state legislatures and here in New Jersey. So in 2019, our legislature passed an amendment to the law against discrimination, which, as you know, entitles people to bring their discrimination claims to Superior Court and have them heard before a jury and have relief decided in that forum. Well, case law had allowed those disputes to go to arbitration. And the legislature in 2019 decided that it would attempt to put a bit of a curb on that practice. So they passed a series of amendments to the LAD, including section 12.7. 12.7 now does not permit those arbitrations to be agreed to as a pre-waiver matter. That issue sparked some controversy. in a number of places. I'll read specifically what 12.7 says. It says, any provision in an employment contract that waives any substantive or procedural right or remedy relating to a claim of discrimination, retaliation, or harassment shall be deemed against public policy and unenforceable. And it also says that no right or remedy under the law against discrimination or any other statute or case law shall be prospectively waived. So clearly the state legislature was trying to prevent those claims from being given up in advance to an arbitral forum. The provision, though, was called into question in both federal court and state court. Most recently, in an appellate division decision by our own state court, a case called Antonucci versus Curvature Nuco, Inc. The appellate division issued a published decision that looked at that provision, section 12.7, and looked at the FAA and concluded that the FAA did not permit the state to pass that law, and the FAA would have preemptive effect to preclude it from having operational effect. That holding happened to be consistent with a decision that had been issued in federal court by Judge Thompson in New Jersey Civil Justice Institute versus Gruhl, the former New Jersey Attorney General. She also looked at section 12.7, and in this decision, which is not for publication, but is on all fours with the published decision issued by the appellate division and written by Judge Gilson, concluded that the FAA preempted section 12.7, at least as applied to an FAA governed arbitration agreement, because it in effect singled out a defining feature of an arbitration agreement, specifically waiver of the right to go to court, which is at the heart of what arbitration is all about. So in Antonucci, the appellate division sent the case back. The trial court had reached a similar conclusion, but had dismissed the action. The appellate division sent it back and said, no, you stay the superior court action and the arbitration and let things proceed. And that's consistent with the preemption analysis that was done by Judge Thompson in federal court. Now, we thought that was pretty significant, and originally we're going to be talking about that and what lie ahead on the federal legislative horizon. But since we began planning this program, Congress acted, and President Biden signed into law a new amendment to the FAA. And we're going to be talking quite a bit about that because it's very important. This new amendment is titled Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. It was signed into law on March 3rd, so it's very recent. In a nutshell, this statute, which applies prospectively, applies to any claim or dispute that arises or accrues on or after enactment of the act. And under this law, it says that no longer can employers mandate arbitration of a dispute, that's the word, or claim involving sexual assault or sexual harassment, as those terms are understood under applicable federal, tribal, or state law. So let me just point out to you precisely the language that that Congress has used. The term pre-dispute arbitration agreement means any agreement to arbitrate a dispute that had not yet arisen at the time of making the agreement. So basically any agreement in advance before the claim arises. Sexual assault dispute is defined to mean a dispute involving a non-consensual sexual act or sexual contact, as such terms are defined in Title 18 of the federal statutes or similar applicable tribal law or state law, including when the victim lacks the capacity to consent. And sexual harassment is also a defined term to the extent there is a definition in this act. It says it means a dispute relating to conduct that is alleged to constitute sexual harassment under applicable federal, tribal, or state law. So there it references back again to state law. So now here's the pertinent prohibitive language. It's in section 402 of this new act. And it says, notwithstanding any other provision in this act, at the election of a person alleging conduct that that person believes to be a sexual harassment dispute or a sexual assault dispute, or a representative in a class, but I'll leave that aside for now. No pre-dispute arbitration agreement or pre-dispute joint action waiver shall be valid or enforceable. So there's many operative words in that sentence that I read to you. The other point of interest in this section, which is, again, the operative provision of this new law, is the determination of applicability. It says that when an issue arises as to whether or not this chapter applies, that's going to be determined under federal law. And the second sentence of that important paragraph says, the applicability of this chapter to an agreement to arbitrate and the validity and enforcement of an agreement to which this chapter applies shall be determined by a court rather than an arbitrator, irrespective of whether the party resisting the arbitration challenges the arbitration agreement specifically or in connection with other terms of the contract containing such agreement, and irrespective of whether the agreement purports to delegate the arbitrability decision to an arbitrator. So we have a lot going on in that rather long sentence. Clearly, the Congress has used some very strong language in declaring what they want to have happen, but there are a number of issues that may arise over the implementation of this new law. As I said, it just went into effect March 3rd when President Biden signed it, and it applies with respect to any dispute or claim that arises or accrues on or after the date of enactment. So the claim has to arise afterward. The statute's going to raise many planning issues for employers, strategic issues for employees and their representatives. So I'm going to turn now the program over to our esteemed colleagues who are well-versed in representing both sides of such disputes. Ryan, I think you're up.
Yes, thank you so much, Justice. That was a very informative background. And thank you, everybody, for having me. I would say I would love to see you all in person, but then I saw the Oscars last night, and it occurred to me I didn't want to say anything that would offend anyone to get the Will Smith treatment in person. So I'm kind of glad that we're all on Zoom now. But first, from the employer's perspective, I wanted to start out with the Antonucci case and just share my view of where I think you can marry that with the current FAA amendments. And I think the consensus is that employers are still going to be able to enforce their arbitration agreements as to all other LAD claims, except sexual harassment claims, okay? And that's just simply because the FAA's amendments were clear that this was going to be limited to sexual harassment claims. I'll also note that that decision, the Antonucci case, was in February. Since then, there's been 2 other unreported decisions by the same panel, led by Judge Gilson. One was on March 11th, and that was in a Chili's case called Salters versus Brinkler International. There wasn't much discussion on the FAA's amendment in that case because it was an LAD race case, but the panel simply just relied on its reasoning in the Antonucci case. And then recently, thank you to Jonathan for circulating this case, just issued this morning by the same panel. That's the Conduit case. Once again, there wasn't a lot of discussion by the panel on the FAA's amendments because the case did not involve sexual harassment. But once again, the panel seemed to confirm that the FAA's would actually, all other LAD claims would be preempted by the FAA. So now turning to the FAA's amendments, I just wanted to share my overall philosophy before we get into the weeds, which is really consistent with two cliche sayings. And the first one is, if you can't beat them, join them. And what I mean by that is, it is what it is. And if there are claims that are in fact covered by the law, which we'll have to see, there's obviously a lot of those issues that still need to be answered. But if those employees do elect to affirmatively go to court, then so be it. We'll go to court. That's what we've always done as employers. The second cliche saying is, it's not over till it's over. And what I mean by that is arbitration agreements generally aren't going anywhere, at least anytime soon. This particular law, as well as other bills that we're seeing, like the FAIR Act that are pending, it's clear that the crux and the focus is against forced arbitration. Okay, the key word being forced, not all arbitration. So the law now with the FAA amendment simply just gives the employee the right to elect to go to court for sexual harassment and assault claims if they accrued after March 3rd. But what I think this means for employers is that we really have to understand that the attack now and in the foreseeable future is going to be against this concept of forced arbitration once a claim accrues. So that means that we have to go back and we have to evaluate what can be done to make it more attractive for employees to agree to arbitration. I know Kelly on the other end of the panel is probably rolling her eyes and saying that there's nothing that the employer could ever do to make me and my clients want to affirmatively agree to arbitration. But two of the things that I'm starting to see that are big ticket items that larger employers have been doing even before the amendments is they're hiring outside neutral experts to really take a comprehensive and periodic review of their arbitration programs. They want to review them to ensure that at the end of the day, they're not negatively impacting an employee's ability to seek redress. There's fairness, there's transparency, they're obtaining data from a cost perspective, from how long it takes an arbitration from the inception to the conclusion versus other court cases. There's surveys. And what these neutral experts are doing are providing a report that businesses are sharing with the workforce. There's going to be recommendations, and then the employer can choose whether or not to implement those recommendations. The other kind of big ticket aspect that larger employers are doing is that when they're rolling out these arbitration agreements, usually at the start of employment, there's going to be more training and educational programs on them. You're not going to see them just included in an employment application and that's the end of it until an employee decides to bring a claim. The goal now is to really educate and make the employee familiar with the arbitration process before it's time to know whether or not they're going to elect. And there's even other things that employers of all sizes could try to do to make it more attractive. I've seen recently employers include in their arbitration agreements provisions that would allow the employee at their election to publicly disclose any arbitration decision. And again, that's going to help mitigate the concern that arbitration is just there to silence victims. So if the employee wants to disclose a decision, win or lose, they could do it. Another item that employers are starting to consider is whether they want to waive any initial filing fees if an employee wants to go to arbitration. They're usually not significant, but in most agreements, the employee is responsible for dishing out those fees. And there's actually a more recent clause that I've started to see in arbitration agreements. JAMS has it on their website. It's a diversity clause where parties could actually agree in their arbitration agreements to have language requiring there to be an attempt at a diverse panel. And I actually included or pulled the sample clause that JAMS has, at least from their website. And this sample clause says the parties agree that wherever practicable, they will seek to appoint a fair representation of diverse arbitrators considering race, gender, ethnicity, and sexual orientation, and will request administering institutions to include a fair representation of diverse candidates on their rosters and list of potential arbitrator appointees. Again, this can help squash any kind of concern that there's bias among arbitrators out there. Just another more obvious consequence from the bill, and I think this is a good segue to see Kelly's view on the FAA's amendments, but of course, this is once again going to emphasize even more for employers that there's a need to focus on harassment prevention, right? With training and robust policies in place, because the expectation I hear generally is that there's going to be an increase in sexual harassment cases from this. So I'd like to hear what Kelly would have to say and whether she thinks from the employee's perspective that there are indeed going to be an uptick in sexual harassment cases.
Good afternoon, everyone. Thank you all for having me. This is an exciting topic in the world of employment law, so I'm happy to be able to be speaking about this. To address Ryan's point about the uptick of sexual harassment claims, I do think that there is going to be an uptick in claims, but not because I've seen written since this law was passed that attorneys are going to try to sneak in sexual harassment claims. I don't really think that that's going to be the case, because we're not in, we aren't going to be making up claims. If sexual harassment doesn't exist, it doesn't exist. We can't plead it. So what I do think is going to happen is that attorneys have seen arbitration agreements and basically decided they don't want to deal with arbitration. And I think that there are a lot of cases that plaintiffs have that aren't being brought in court and aren't being dealt with at all because they can't find an attorney who really wants to handle a case in arbitration. Now that they have the ability to go to court on these claims, I do think that because of that, you are going to start seeing an uptick in the number of sexual harassment cases that are going to be filed. With regard to the plaintiff's bar, I think that that's a good thing, because you've got people who believe that they are the victims of sexual harassment and now are actually going to be able to potentially have those claims see the light of day in court versus, calling several attorneys and having to disclose that there's an arbitration agreement and attorneys basically deciding they don't want to deal with the hassle of arbitration. The issue with regard to the forcing employees into arbitration, as a lot of you are aware, the arbitration agreements tend to come up a lot of times in the employment application. I can't tell you the number of cases where when I'm talking to a potential client, they'll mention that, oh yeah, when they were first applying, they had to fill out they had to submit the resume, they had to fill out an employment application, and they had to sign this document that said something about arbitration. They don't really remember it, but they couldn't apply to the job without signing it. And they wouldn't be considered for employment if they didn't sign it. So I think that in that respect, obviously, as far as the sexual harassment, sexual assault aspect goes, that those cases are automatically, employees are going to be able to elect to go to a jury, to a trial. Where I think the issue of the forced arbitration, and Ryan and I were having this conversation last week when we were talking about what we were going to say today, is that when you're discussing the issue of executive level employees, where now employers have the ability to potentially negotiate these arbitration provisions, where when you're talking executive level employees, you're just typically a back and forth. Sometimes if it's a really high level position, you've got attorneys involved, and employers can kind of use the arbitration, an employee can use the arbitration as a bargaining chip. Hey, well, I'll agree to sign this this arbitration agreement cover everything, including what's covered under this law, but then move on to and then have them get something in return as part of the negotiation process. So I think we will be seeing that a lot when we're talking about executive level positions. I'm no longer an attorney for employers, but I do envision that a lot of arbitration agreements going forward are just going to very likely carve out the sexual harassment and sexual assault, simply because that likely will cut down on litigation, or at least preliminary litigation about what to do with the arbitration agreement. One of the other things I think in the short term with regard to this law, as Justice Lavecchia mentioned, is that it's going to lead to a lot of initial litigation, a lot like we saw when the New Jersey legislature passed its arbitration, its employment arbitration bar. So I do think that issues with regard to whether it's covered, what is covered, that type of thing is going to pop up a lot. One of the other things that Ryan and I spoke a lot about, and I'll turn this back over to Ryan to touch base on, is what's going to happen when we have multiple claims where there might be sexual harassment, but there are other claims in addition.
Yeah, I think that's going to be one of the issues that's going to be front and center pretty soon. And from the defense view of it, is that the FAA has to be interpreted in a way where it's going to presume that if there's any dispute, it has to fall for the presumption in favor of arbitration. And that was back with the Moses v. Cohen case by the United States Supreme Court. So I think there's going to be a narrow interpretation as to whether or not there, these other claims that aren't themselves sexual harassment, like a quid pro quo claim or a severe and pervasive hostile work environment claim, those are clearly, sexual harassment as defined by the Lehman case and its progeny. But if a plaintiff attempts to bring any other LAD claims or wage and hour claims, I think that the position the defense is going to take is that we have to narrowly interpret the FAA in favor of arbitration. There's a presumption in favor of arbitration. And if there's any question as to whether or not those claims are arbitrable, they should be construed in favor of arbitration. But you also raise a good, interesting question, Kelly, from the defense view about what are employers doing right now with their arbitration agreements. But to be frank, most of the clients that we counsel, and from what I've been hearing, no one is running to modify their arbitration agreements to make that carve out just yet. I think if you really wanted to be conservative about the new law, you can consider carving it out. So in the event that the employee does have a sexual harassment claim that accrues after March 3rd, 2022, they've gotten that notice that they have the right to go ahead and elect to file in court. But I think right now it's a wait and see approach. And there's nothing that I see in the law that would void or invalidate any arbitration agreement right now. The only thing that happens is if and when the claim actually accrues, and if that happens after March 3rd, 2022, the employee will then have the right, and they have to affirmatively elect to do so, to bring that in court. So that's where I'm seeing things right now. I think that there's a middle ground approach. If employers wanted to, they could simply send a notice to all their current employees who currently have arbitration agreements and just say, sort of an FYI, under this new FAA amendments, that if and when the employee has a sexual harassment or assault claim that accrues, you have the right to elect to go to court instead of arbitration. This way, there's no issue later on whether or not the employee got notice. But right now, I think that most people are staying put.
I just add my 2 cents here. From word of mouth, what I hear, I do not sense there is a rush to, just toss in the garbage can existing arbitration agreements either. Maybe discussion of going to carve-outs, but this is an issue that is broader than just employment agreements. It can affect franchise agreements and settings where wrongful sexual contact may take place, and yet customers of, say, spas sign agreements when they go to such organizations and utilize their services that often contain arbitration agreements. So what Ryan and Kelly are talking about are considerations that are happening broadly in the economic sphere. One other advantage of leaving it in that I think probably seems apparent to anyone is that by leaving the clause as is, the employer does have the ability to identify the preferred source for selection of arbitrators, as opposed to just simply abandoning wholesale an arbitration agreement that exists now or a clause in its entirety.
That's a good point. And another point on when you have these mixed claims, when it's clear that a plaintiff has this sexual harassment claim, but also has 2 or 3 other counts, there's always the question of, practically speaking, whether the employer is going to want to have bifurcated litigations and parallel, claims going in arbitration for sexual harassment, and then these other claims in arbitration. I would say that in most cases, employers are going to want, for efficiency reasons and cost reasons, everything in one venue versus the other. So I think it's really on a case-by-case basis. So if I'm an employer representing an employer, and I know that the meat and potatoes really is this sexual harassment claim, and the other claims are really ancillary, then I may want to say, okay, argue to the judge, because the court now has to decide these issues, that you can send these other claims to arbitration pursuant to the arbitration agreement, because they're not impacted by the new law, but we're litigating only the sexual harassment claim in court. Another interesting thing that we've thought of as a sort of counseling perspective is to include language in your arbitration agreement that says, when the employee elects to go to court with respect to the sexual harassment or assault claim, and there are these other claims that are subject to the arbitration agreement, it's up to the employer whether or not they want to keep everything in court or just have the bifurcated litigation, subject to being consistent with law. So that's another thing that we're looking at right now as employers. But going back to what I said earlier, at this point in time, no one's rushing to revise any of their agreements, and it really is a wait and see approach.
In one moment, I'm sorry, were you gonna say something, Kelly?
No, go ahead.
Okay. In one moment, I'm going to introduce Dean Burrell, who you may see on your screen there, who's well known as the Will Smith to my my other comedian who gets slapped. Why can't I recall his name? I know
Chris Rock.
Chris Rock. Yeah, I jammed up there for a second. But anyway, but I know what Dean is gonna. Dean has a good question about the legislative history of the federal law. But before I kick it to him, just curious from Kelly's perspective, is there anything that someone like Ryan could offer you as the employer to say to you, hey, look, rather than litigate this piecemeal, I know you've got a sexual harassment component to your client's claims. Is there something that I can do for you that would entice you to arbitrate the entire claim?
I think that would have to be a case-by-case basis, but I mean, I think the practical thing that's going to end up happening is a lot of these cases are going to go into mediation early to see if both parties can avoid having the issue of a bifurcated case go forward. That's the bifurcation, I think, kind of defeats the whole purpose of why arbitration was even created to begin with, which was a way to have litigation go faster and be cheaper for all parties involved. But now if you're talking about, bifurcating these cases, that's not helpful to the employer. It's certainly not helpful to the plaintiff. So I don't know if there's, I don't know if there's anything specific with regard to agreeing to go to arbitration, because at least for our perspective, it's not costing us, that's the employer's responsible for those costs. So it's not even like we can argue, we'll take over whatever your costs are with regard to the arbitration. That doesn't really happen. But I do think that early mediation is probably something that's going to be suggested a lot and beneficial to all parties.
All right, so actually, Dean sent me a comment. He said that he's not like Will Smith because he wouldn't use an open fist with me, which is quite a scary thing to say. I'm glad we're not in person. Dean, you had a question about.
Well, I got a few items, and I cannot begin to tell you how much I'm enjoying hearing from the justice and Kelly and Ryan.
One second, can I interrupt you? I'm sorry. I forgot to mention, Dean is not only a board member of New Jersey Labor Employment Relations Association, he is also the incoming president of the New Jersey State Bar Association Alternative Dispute Resolution section. And Dean is too humble to tell you that himself. So I think we all need to congratulate Dean for that. And I'm sorry for interrupting you. Please, no violence.
Yeah, when you think of me, you do think of humility. That's for sure. First, thank you, Jonathan. I'm a labor and employment arbitrator and mediator. So let me make very clear, as a neutral, I take no position on the statute. My job is to interpret the law. My job is to interpret the contract between the parties. My job is to render an unbiased decision, be it employment, be it labor, or be it mediation, whatever the venue is. My job is to act without bias. However, as an attorney of color and the former president of the Black Barfoot estate, I was struck when I first read this, because it only applies to sexual harassment and sexual assault cases. It excludes the other protected bases of Title VII, gender, sex, religion, race, etc. And I called a buddy up on the Hill and I said, how's it come? And he said it wouldn't have passed. And I think that reflects the political reality here, and really the changing times. If you look at Title VII, it originally, sex was added by Southern congressmen to try to sink Title VII because they didn't think it would pass. With this legislation, it was co-introduced by Lindsey Graham and Gillibrand in the Senate. I don't see Lindsey Graham co-sponsoring a statute that would expand the scope. As a matter of fact, there was a reference by Ryan to the FAIR Act. The FAIR Act itself has been introduced, and that would exclude arbitration for race, religion, and all the Title VII bases. That's been introduced the past several years in Congress and has no chance of passing at this time. So that struck me. A few other things struck me. The first is, I think the act deals with three areas, and it's not just sexual harassment / assault. It also deals with the Epic Systems case. Epic Systems is the case where the Supreme Court several years ago stated that class action waivers were enforceable. It originally started as an NLRB decision, D.R. Horton, and evolved its way into the Supreme Court. So that is the second area it impacts. The third area it impacts is a decision from 2 years ago called Harry Schein in the Supreme Court. And in that case, the court stated that it is up to the arbitrator and not the courts to determine arbitrability, which in the labor world, even though there's been some back and forth, that's a pretty familiar concept. So I think this act now raises essentially an area of dual enforcement. So you're going to have sexual harassment cases that cannot be subject to arbitration. However, everything else would be. And we have the Antonucci decision, which was referenced by the justice earlier. We actually had a case several days ago, Ramadan decision, which dealt with a claim of religious discrimination under LAD. So you're going to see those types of cases go forth in arbitration where there is an arbitration clause. You're also going to see the courts now interjecting more and more in the area of sexual harassment cases, because not only do you have the ban, but now you also have the courts determining arbitrability where there is an arbitration clause. Whereas for other types of cases, that will not be the case. I think the end result, and this is purely practical, is more cases will go to the courts. But right now, as those of us who do this know, there's a tremendous backup. As an employment mediator, bluntly, this is going to do wonders for my practice because folks are not going to want to wait 4 or 5 years to have their case heard because between the backlog that already existed and COVID, which shut down the courts and things are just starting to come back, you're going to see a significant increase in employment mediation. I think there's some other issues that are still outstanding. For example, what about a statutory claim that arises through a collective bargaining agreement? I do a fair amount of traditional labor arbitration, and right now, FMLA cases and ADA type cases arise all the time through collective bargaining agreements. It is rare to see a racial harassment or sexual harassment case, though not unheard of, if the parties wish to do that post-Payette. So I think there are a number of interesting issues. Also, what happens when you have that kind of mixed case that we discussed, or something that's arisen under what's called a hybrid 301 type case, where individuals are suing their employer and their union, and it's a sexual harassment claim. So it's unclear what that means. Arguably, EPIC says that the FAA has greater standing than the NLRA. Don't know. So I think to Kelly's point, there's going to be a fair amount of litigation to see this. Also, are there going to be multiple bites of the apple? For example, where you do have a race claim and you do have a sex claim, this is similar to Title VII actions going before the EEOC and also a pending arbitration.
Hey, Dean, I'm gonna need to stop you. I'm sorry,
Sure.
but you ran out of time on your question. This is on Jeopardy. We are accustomed to people answering in the form of a question, and you asked your question in the form of an answer.
Yes, sir.
Quite a lengthy answer, I'd have to say.
Don't
But
make me
you know,
Will Smith.
but once you get Dean wound up, that, and it was very informative. I do want to give it back to the panelists, though. So, with all due respect, Dean, it was very helpful, though. So for the panelists, as to the first point Dean raised, I was actually debating with Dean about this. It seems to me that although there's obviously a cumbersome issue that you guys have already tackled relative to a typical complaint where you've got sexual harassment and, let's say gender discrimination and racial discrimination, how does that proceed? But is there really anything inherently problematic about picking out sexual harassment and sexual assault, it seems to me that it's Me Too legislation, and that it really is intended to try to bring out into the sunlight the types of things that we saw over the last couple of years, where wealthy men in particular, but it could be anybody, were sort of, having a recidivist type of harassment, and just, making the plaintiffs sign non-disclosure agreements. Perhaps having secretive arbitration could lead to more of this to happen, and that type of repetitive behavior where it's not stopping our Harvey Weinstein. And, obviously people who could be victims of sexual harassment and sexual assault is anybody, right? It doesn't matter your race, doesn't matter your religion, it doesn't matter your national origin, your hereditary blood type, right? These things can happen to anyone, your gender, right? So it doesn't seem to me to be a racist law or sexist, or somehow exclusive in terms of what it does, but perhaps cumbersome. So on that public policy point, does anybody want to weigh in?
I mean, it's tough to really understand why they did just single out the sexual harassment and assault. But Jonathan, to your point, part of it is likely due to the timing. It was at the heels of the Me Too movement. If you read the legislative history, there was a lot of testimony. Gretchen Carlson, no relation to me, but she was there. There was a lot of discussion with the massage envy cases. I believe there was over 400 sexual harassment cases that were all sent to arbitration. And, part of the concern was there about silencing victims and the power dynamic. But, I do understand the issue that can be viewed as singling out one form of discrimination and claims versus others.
Anyone else on that?
Yeah, go ahead, Justice.
I'll be brief. I would echo Ryan's observation from the legislative history. There's many statements in this record by legislators about the Me Too movement and the desire to not silence victims, to allow them to speak in concert, which is, to Dean's point, class actions will be permitted here. So if there is a wrongdoer embedded in some employment setting that has repetitive conduct of inappropriate sexual contact and harassment, this bill will certainly allow those cases not to be cabined into arbitration, but will be forced into the light of a public forum, which the courts would provide. In some respects, forgive the term, but it was almost low-hanging fruit to go after these claims as opposed to the broader group of claims that Dean mentioned that are being kicked around in the FAIR Act, which would eliminate forced arbitration for any employment claims, any civil rights claims. And I forget what was the other category, but it's civil rights and consumer fraud. So that's a much broader attack on arbitration as a whole and a much heavier lift. This came on the heels of several instances of public outrage about behavior, and much was made of it in the record and at the time of signing. I'm curious to hear from Kelly as to an employee's perspective on the problems of bifurcation, because it seems to me that it raises a number of concerns for somebody who feels they've been wronged and is looking for quick remedy, efficient remedy, and bifurcation certainly doesn't advance either of those goals.
Justice, I completely agree. A lot of times when we speak to, to clients, it's one, a lot of times they don't really understand the litigation process to begin with. And, yes, going into court takes a long time, but I'll be honest, I have several cases that are in arbitration that are going on 2 years now. So it's not always quick, regardless of which direction you go in. But yes, I think the bifurcation is going to create, the potential for bifurcation is going to create a lot of issues for people who might, a year in, want to just be done with this. They dealt with it. They experienced what was going on at work. They are now having to, relive it in depositions and responding to discovery, and now having to potentially do that twice because, you might have to take two separate depositions because, if there's a race claim, you're not presumably the defense is not going to want those issues to pop up in the deposition with regard to just the sexual harassment aspect, and vice versa. So I do think that is going to certainly become a bigger issue than it already is with plaintiffs who are already, get upset at how long the process takes to begin with. If you're telling them now you might have to do this double and it's going to take just as long, I agree that's going to be conversations I think a lot of us will be having with clients with regard to what to do.
I have a question for Ryan on that point. In terms of a bifurcated case, let's say that you get a complaint from an employee filed in Superior Court. It includes, let's just say, both gender, just to highlight this point, disparate treatment based on gender, Equal Pay Act type of claim based on gender, perhaps along with a sexual harassment, right? And you move to force arbitration as to everything but the sexual harassment claim, because you can't move to force arbitration on a claim that accrues after March 3rd on the sexual harassment component, right? So you're in that situation. What would be your preference as the employer? Does one case stop while the other one goes, or do they both go full steam ahead at the same time? And then, do you hope that the judge and arbitrator are almost paying attention to what the other one is doing, so that way there's some synchronicity to the entire thing, both with respect to discovery, with respect to motions, some level of reciprocity between decisions that are made, in the two fora? I mean, can you imagine the situation where you get one ruling from an arbitrator, saying you can't do this, and then, or you can't have her cell phone, and then in the other case, the judge says, sure, you can have her cell phone, right? I mean, what kind of concerns do you have on that, Ryan, and how would you recommend handling it?
There's a lot of concerns, and it's really tough to really fully comment on it unless you kind of know what kind of case is in front of you. I think there may be times where you want to go full steam ahead with the case in arbitration. If there's if there's a way to get testimony for impeachment purposes that you want to get and then use in a case in court, that might be advantageous to the employer. But there's not going to be any res judicata or estoppel sort of effect, I think, if they are separate claims. So, on balance, we're probably not going to want to have those bifurcated cases. Again, the one example where I see maybe we would want to do that, and maybe it's to call the plaintiff's bluff, is if we really do see that there's a tack-on sexual harassment case solely in an attempt to try and get everything in court. Maybe we'll compel arbitration on all the other claims and just simply litigate the harassment claim in court to see what the plaintiff is going to do in that regard. But really, the employer is going to want everything in one venue in most cases.
Responses from other panelists?
The employer may not have that option. I think any smart plaintiff now, especially with the elimination of the class action ban, is going to file multiple cases, and they're going to bifurcate it. And frankly, if I'm the plaintiff side, is good leverage. It's a good way to get these cases settled on friendlier terms, and I may be otherwise able to get them settled.
We're really deep in the practicality, which is great, and that's really what we pride ourselves on. But before we get any further in that, I think that what struck me from the Antonucci decision from a public policy perspective is, having read enough employment decisions, it gets drilled into your head, the Supreme Court of New Jersey's admonition that the New Jersey legislature sought nothing less than the eradication of discrimination and harassment in the workplace. I'm probably butchering that quote a little bit, but we all know what I'm talking about. So 2019, I think it was, the legislature, sits down and passes a law. The governor signs it, and what they want to do is stop employers from being able to force employees to arbitrate. So just putting aside the federal law for just a moment, with Antonucci, I'm sure the plaintiff's attorney isn't pleased with the outcome. Is there a concern that the courts in New Jersey just aren't getting it right at this point, because the intent of the New Jersey legislature is not being served or not being effectuated? And is that a problem, or is it just something that they should have seen relative to the FAA? And that was a blind spot for the legislature and just missing the Federal Arbitration Act. Anyone?
You saw Dean and I both nodding our head up and down. How could a court ignore the FAA and the strong body of case law that has said it controls? The New Jersey courts have not a free hand in this, under the United States Supreme Court case law, which has been very forceful, including, the most recent Kindred case by Justice Kagan. I mean, that could not have been plainer speak, I think, in terms of how that court is approaching arbitration law.
When 12.7 was passed as SB 121, the general consensus in the employment law community on both sides was that the NDA piece would survive, but that the FAA piece would be found preempted, the ban. So it was more symbolic, and that's why you had the cases that the justice referenced earlier, the Civil Institute, there was a case, Janko, and then finally you had Antonucci. So none of this is particularly surprising.
Was it really symbolic, or was it a mistake by the legislature? I mean, I don't think that they were trying to be symbolic when they said, you're not going to be able to arbitrate anymore. They just seems like there was probably nobody there who said, well, what about the FAA? Of course, not having been in Trenton at the time,
Right?
Really comment.
Jonathan, on that, we talked about this last week briefly, but there seems to be one outstanding issue from the Antonucci case, is that panel limited its holding with respect to the FAA. So it didn't analyze the agreement solely under the NJAA, the New Jersey Arbitration Act. So there could be a circumstance where you have an employment arbitration agreement that's not covered by the FAA. For example, if you have transportation workers involved in interstate commerce, the FAA won't apply. And if there's a discrimination case brought under the LAD in that case, then you might have a panel who's going to have to decide whether or not the LAD's recent March 2019 amendments, they're going to clash with the NJAA. And that would be a very interesting case to see how they turn out in that.
And that's the whole Uber v. Singh and those FLSA cases. But yeah, you're right. And the NJAA is really what I view as almost a default setting, which is if the FAA doesn't apply, then to your point, the NJAA applies, and there's still going to be arbitration required unless it's a sexual harassment case.
Anything on that, Kelly, before I ask another question?
No, you can go ahead.
Okay. All right. So, this may be old hat for the pros on this panel, but it seems to me interesting, at least, what you view as being sort of pros and cons of litigating a case in arbitration as opposed to in the courts. Obviously, the court, some of the things that steelworkers said back in the 1960s that are still quoted today about arbitration being the less expensive, swifter means of adjudication might not necessarily be true anymore, at least pre-COVID, when you could still get to trial in 2 or 3 years. But obviously the discovery is going to be different. Instead of having a 450-day discovery period with a judge with hundreds of thousands, not hundreds of thousands, but thousands of other cases, you've got an arbitrator who you're paying to pay attention to your case specifically. So what kinds of considerations do you think go into the, maybe what makes them different? How do you do the cases different? Is there an advantage to one or the other depending on the facts of a particular case maybe?
We talked about this a little bit last week, and I know one of the things that we discussed was the issue of if you've got some serious discovery disputes going, that it sometimes in arbitration might be easier to get a hold of the arbitrator and have the issue dealt with in a phone call versus dealing with having to file motion upon motion upon motion and have to wait for a motion return date and then potentially have to go back if whatever the dispute isn't resolved. So I do think in that respect, it makes arbitration is appealing, but I also think that's limited to, cases where you might have a lot of paper discovery, or there might be big ESI, discovery involved. It becomes less of an issue when you're dealing with a run-of-the-mill case where, there just might not be that much paper discovery. You're less likely to be dealing with really big discovery issues. So yes, I think in certain circumstances, that issue is better suited to arbitration, but I'm not sure that you would know that necessarily at the onset of the case to be able to make that determination.
Ryan?
Yeah, I would say from the employer's perspective, on balance, yes, they're usually quicker, they're less expensive, but it really curtails the idea of a runaway jury verdict. And I think that, I've frequently moved cases from court where a settlement demand was, in our view, astronomical. Then we prevail on the motion to compel arbitration, and the value of the case goes down substantially from the plaintiff's end of it, at least in my experience. So for those reasons, it's very advantageous to be in arbitration. But I'll tell you that there's some times when you have a case in arbitration from the employer's perspective where it's frustrating, particularly with the dispositive motion practice, right? In my experience, it's more difficult to prevail in a dispositive motion. Summary judgment motions are less likely to be granted in arbitration, and you're more likely to get a hearing than in court. Actually, a case in point, 2 or 3 weeks ago, there's a Third Circuit case called City of Sunbury. I think it's House versus City of Sunbury. And the employer moved to dismiss under a 12B6 motion because it appeared to be a slam dunk motion to dismiss that a court would ordinarily grant. But they also argued in the alternative that the case should be compelled to arbitration, and ultimately went up to the Third Circuit and they said, you have to decide the issue of arbitrability first. You can't get eager to get into the substantive motion to dismiss. But just reading the mindset of the employer, they probably knew that we're not going to get that chance to dismiss as early, and probably not the odds of granting it if we went directly to arbitration versus court. So that's a real issue that we experience on cases that we think should be decided on a dispositive motion normally in court. The other issue that we run into sometimes with arbitration is discovery. Is in large cases, third-party discovery could be relevant, and we want to take third-party depositions, expert depositions, and the FAA does have limitations on an arbitrator's ability to compel production of a third party for testimony at any time before hearing. So, those issues are at play sometimes, but on balance, the employer is always going to prefer arbitration.
Anybody who has any questions, by the way, I should have told you this, please put them in the chat and I'll be monitoring that. In the meantime, I'll ask another question. With regard to this accrual date in the FAA, so the specific language, I know there was some talk about this, but I don't think that this question was fleshed out entirely. So it says that it shall apply with respect to any dispute or claim that arises or accrues on or after the date of enactment of this act. So from a practical perspective, does that mean, I mean, so many sexual harassment cases by definition are continuing violation cases. Obviously, you have your handful of severe incidents, as you know, on the severe or pervasive scale, you know, of a very severe act, but frequently these cases are more death by 1,000 cuts or, you know, continuing harassment allegations. Do you foresee that as an issue, Kelly, where you've got somebody who, you know, you allege, you know, maybe they're still in the workplace now, hypothetically, but they allege that they've been harassed continually going back, say, for 3 or 4 years or 1 or 2 years, if you want to keep it within the statute of limitations, but that, you know, and perhaps a very severe incident happened 3 months ago before March 3rd, but it's continued until now. So you should be able to get the benefit of this and be able to stay in court if you want to. Any thoughts?
So I think this is one of those instances where it's going to lead to a lot of early litigation on these issues. With regard to, I think with regard to any kind of continuing violation, I think there's a good argument to say that those would potentially all get pulled in, because that's generally how the continuing violation doctrine works anyway. At least it's a plausible argument. I think the bigger issue is going to be when you might have some discrete acts that occurred pre and post March 3rd. So, you know, you could have had a suspension or some kind of retaliatory demotion or something like that that occurred pre March 3rd, but still within the statute of limitations. So all, you know, ongoing this, and then post March 3rd, you've got a termination, a retaliatory termination. And then what do you do with that? Because the termination, obviously, if you're claiming it's, you know, it was based part and parcel on the sexual harassment and all that, then you have the argument that you can't go to arbitration. You shouldn't be forced to go to arbitration on that. But if you've got some kind of retaliatory suspension or demotion because of a complaint that you made earlier on sexual harassment, is the employer going to try to force bifurcation of that? Is, you know, or is the court going to say that's, you know, that doesn't make any sense, we're just going to have it all go to court? I think that's going to be a lot. I think we're going to be seeing that happening, at least in the short term, while, you know, we're still so close to the date that the law was signed. That's going to pop up.
Hey, Jonathan, you actually raise a pretty interesting dilemma for employers, which is the employer prefers arbitration. However, to do that, there's going to have to be some contention regarding a continuous violation, to your point. But if the employer is wrong, that increases the damages that could be awarded against them. So it's a pretty interesting dilemma.
Another question, I guess, would be, is that an issue for the arbitrator to determine the accrual, or who decides that issue?
I mean,
Well,
I
I
would,
think under 402, it says all issues about the applicability of the act go to the court.
Okay.
Yeah, I would say so too.
It goes to the court, but again, I'm thinking about Harry Schein, which says that it's up to the arbitrator to determine arbitrability.
Yeah, but I think that language is addressed specifically in the second sentence of 402B.
Mm-hmm.
Don't you think?
Well, I think it's a chicken or egg.
Irrespective of whether the agreement purports to delegate such determinations to an arbitrator, whether the chapter applies shall be determined by a court rather than an arbitrator. Obviously, early cases that Kelly and Ryan are talking about are going to have to reach that argument that you're raising, Dean, because it's a good one.
Interesting procedural point too on this process when we're going to have courts decide these issues is from the employer's preference, we want federal courts to decide these issues if we can get a case removed there. And the reason is win or lose, we have a right to, well, appeal that decision as of right under the FAA, right? So, we had a case where the plaintiff lost our motion to compel arbitration and stay a case. And if the case is stayed in federal court, that's not automatically appealable as right. It's considered an interlocutory decision, and the plaintiff is going to have the elevated burden of getting the Third Circuit to review that. If you're in state court in New Jersey, win or lose, a motion to compel arbitration is appealable as of right for both parties. So it's almost an unfair playing field for plaintiffs to have these issues decided in federal court versus state court.
Is the hierarchy, I guess this is, subjective to some degree, but from an employer's perspective, you want to be number one in arbitration. Failing that, you'd like to be in federal court. And if you can't have that, then state court would be the worst of the options. I suppose from a plaintiff's employment perspective, you'd prefer to be in state court, obviously. Is federal court definitely better than arbitration, or does it, would you maybe depend on the arbitrator? So if you've got some ability to select the arbitrator, and if you get a little give and take, maybe you prefer arbitration to federal court.
I think it would depend on the circumstances and the specific facts of the case, because our biggest argument is plaintiffs should be entitled to a jury to, make the decision. So in that respect, we would, federal court, because they at least get the chance to go before a jury, where that's not available at all under arbitration.
Right. And I think Bill Dwyer has the statistics that he shares with the Rutgers class. So, but there's something like, the idea of a runaway jury, obviously that doesn't happen with an arbitrator. I believe, Bill, you could even jump in if you want to, if you could put Bill in, because I know he knows the answer to this. But I think the average awards are, the median awards are a lot steadier sort of in employment arbitration. You don't tend to have those outlier type of jury verdicts, but maybe that's better because you're not, on the one hand, you have a more definite end to the litigation. Emily, can you bring Bill in here, or Bill, can you talk?
Jonathan, I saw some recent statistics like 2 weeks ago. I don't want to misquote them. I don't have them in front of me, but I can get that out to everybody afterwards.
Sorry for putting you on the spot there, Bill.
No, it's fine. It's fine.
But you agree that there is generally, the number, you don't see the $10-20 million type of arbitration awards as much.
No, not even close.
So it's an interesting practice point. Also, obviously, with the arbitration, you can't just get an appeal for some sort of mistake that the trial judge may have made over the course of a trial. It's a very hard thing. I don't know if there's anyone here who's been a judge on the trial court level, probably Justice Lavecchia, but there's and has read these decisions. There's so many things that could go wrong over the course of a 2-week trial that a plaintiff's attorney or a defense attorney could try to say, create grounds to throw out the jury decision, or at least some portion of it. Whereas under the FAA, the grounds to vacate an arbitration award are exceedingly narrow. You basically have to show fraud, a mistake on the face of the award of significance, undue means, something along those lines. Anyone want to comment on that aspect of the arbitral versus court analysis? We do have a question also.
I would just say that you put your finger on it, Jonathan. The standard for reversing an arbitral award is very difficult to meet in comparison to the standard of review for harmless or plain error made during a trial proceeding. So it's difficult.
Richard Yaskin asked a question that I think we probably should have covered a little bit better and made clear. He asks, does new section 402B preclude the portion of mandatory arbitration agreement in sexual harassment claims, which contains a waiver of the right to a jury trial. If I understand that question correctly, still talking about mandatory arbitration agreements, right? At first I read that. I mean, we know we could still have, an agreement to arbitrate, notwithstanding. What about Richard's question specifically?
Yeah, I think the interesting implication there, and again, I'm putting on my traditional labor law hat, is that in the Steelworker Trilogy, which you referenced previously, the Supreme Court called upon a development of a law of the shop, common law as it regarded collective bargaining agreements. And here it specifically says that a dispute shall be determined as to whether the supply shall be determined under federal law. So I'm not sure how that implicates the LAD. Essentially, it says, so what? It's strictly federal. Not sure
Any of
if
the
that answers the
panelists
question.
have a thought? That's a Richard's question.
I think Dean is reading it right.
Yeah,
I mean, for what it's worth, not that as a neutral, I'd ever be asked to decide that question, but I do think it goes to the courts.
I mean, just out of practicality, I'm out of curiosity, Ryan, if you had your client's telling you this plaintiff who's suing for sexual harassment really has a past where basically the person has confessed to the employer that they have had relationships with persons who've been their employers in the past, maybe even some sort of dirty history that the employer thinks that they could use against the person. If the type of thing that might taint a jury in a traditional case, what plaintiff might call attacking the victim. If someone like Kelly were to say to you, hey, look, I'll arbitrate this case with you, and include the other claims as well, but you have to agree, that you're not going to ask the arbitrator to subpoena past records. You're not going to, go through the person's past, and we're going to really make this case about what goes on here, and we could just stipulate, for the record, certain things about, things that may have happened in the past. And because this is an arbitrator, the arbitrator can just sort of afford whatever weight that they think is right to that type of issue. Would you ever agree to that type of circumstance?
Hey, Jonathan.
Yeah.
And I'm sorry, not trying to be rude, but back to the original question. Essentially, a waiver of a right to a jury trial in this context would mean that if the matter was not arbitrable, you're essentially telling a trial judge that they have to decide this case rather than a jury. And to me, the question is, can a private contract bind a trial judge? And look, again, this isn't coming to me as an arbitrator. I'm just answering this kind of off the cuff. I'm not sure a private agreement can do that. And this may be an ignorant comment on my part, but I've just never seen that before, though I've seen waivers of jury trials, but that's always got to be explicit as part of the mandatory arbitration clause under LAD law.
Okay, so Ryan, you can either answer my question, respond to Dean's comment, or choose some other thing to talk about.
Well, Jonathan, your question, I just worry about the type of precedent that sets for all future cases. And it's an interesting concept. It's more of like collective bargaining with the employer and the employee once a claim accrues over what this arbitration is going to look like and what are the discovery procedures and whatnot. And I don't know if we're going to run with that, what's going to stop an employer from when the employee has a claim and they're deciding whether or not to elect to file to court or arbitration. I could pick up the phone and say, hey, Kelly, if I give your client $10,000, would they just go to arbitration under the agreement? It's just, I think it opens a can of worms. And, you know, at this case, we're just waiting and seeing what the employee is going to do and how they're going to go about electing. All of those, we'll have to wait and see the process. But I would be hesitant to kind of agree to any kind of negotiation over what's going to be in arbitration.
Fair. What about sort of like a high-low arbitration where the plaintiff is guaranteed some recovery? You say start at nuisance value, $30,000, and then put a cap on it. Is that too out of the ballpark where really, you know, it's got to be from 0 to infinity? Or
You mean and limiting the amount of potential recovery for a plaintiff in arbitration?
right. So in essence, we say, okay, we'll go to arbitration, but the arbitrator can't award less than $35,000, can't award more than $5 million, something like that.
It's interesting. I don't know if that would even satisfy AAA and JAM's minimum standards of fairness that they have in place, setting those caps and floors. It's an interesting concept. I mean, again, getting into bargaining over these kind of issues in light of this new law, it's very interesting. I'm just hesitant to even start going there.
I mean, I think arbitration is a creature of contract, so it seems to me that, you know, things might be on the table. But we've reached the 6 o'clock time, so I don't want to keep anybody past, you know, because you feel obliged to be here. So I guess what we'll do is we'll close up and we'll thank everybody for coming. We do have, like I said, on May 2nd, Gwynn Wilcox of the National Labor Relations Board. Dean is going to take his act on the road, and he'll once again, he'll actually be on the dais because it's in person with David Leach, the former regional director of the National Labor Relations Board, who's now also an arbitrator and still a board member at NJ Lera. So we encourage you to spread the word, come to that event. Typically, that's one of our better attended events, and hopefully it'll be beautiful weather on the golf course out in Galloping Hill in Kenilworth, and we usually have good food there too, which we can't offer you on Zoom. So I want to thank Justice Lavecchia. It's really been a great honor to have her come and speak to NJ Lera. As far as I know, she's the first Supreme Court justice that we've had. Maybe there was one decades ago. And Kelly and Ryan, I thought were great. And, you know, they're really two of the, you know, top attorneys, I think, that do this type of law right now. So I appreciate both of them for being here as well. So if anybody has anything and want to, you know, stay after, put something in the comment box, feel free. Otherwise, I hope to see you on May 2nd for my last meeting as president before they give me the hook and put somebody in my place, or before Dean beats me up to the point where I can't be recognized.
Thank you for moderating, Jonathan.
Yes,
Thank you.
It
thank
was
you.
really
Thanks so
interesting
much.
discussion.
Justice,
Thank you.
it was wonderful, and Jonathan and Ryan and Kelly, it was fabulous. Thank you guys so much.
Thanks for having us.
Yes, thank you.
Thank you.
Thank you very much.
All right, take care, everyone.
Have a good night.